The sound you don't hear inside the Beltway these days is that of Republicans exhaling when they start thinking about what will happen if and when the Supreme Court rules against Obamacare subsidies in certain states. Because fair to say there are still plenty of lawmakers wondering what they can and will do once that hammer drops. Maybe they should have been better prepared. Our guest was Chief of Staff to former Health and Human Services Secretary Michael Leavitt, who has gathered other former HHS officials together to provide guidelines for states in just such an emergency. Welcome Rich McKeown to the Hardline. Rich, thank you so much for being here.
My pleasure. Thank you.
Rich, as you look at these states, who is really in trouble? I would guess there's a couple of states right now that if indeed King v. Burwell goes as many people believe it will, they're going to be really scared.
Well, the largest populations that presently are subsidized under the Affordable Care Act are Florida and Texas. And so if you're looking quantitatively at the number of people, and sheer numbers are going to be impacted, they certainly will be. But in relative terms, every state is going to feel this pressure. And the pressure is a significant pressure of those who have been able to obtain insurance under a subsidized situation. And it's a significant subsidy. As much as 72% of their premiums on average are paid for. So each of those individuals will find themselves in a situation where their premiums will either go markedly up or they will find themselves uninsured.
Rich, we've just seen some of the graphic numbers here from Florida and Texas, and I want to reiterate them. Premiums for a single 40-year-old male in Florida could rise more than 570%. And in Texas, the same thing, more than 480%. Is there anything the states could have done before this point to better prepare themselves for all this?
Well, the limbo and uncertainty that's brought about by virtue of litigation is, as you know, paralyzing to a lot of people. And I think people have found themselves in a wait-and-see situation. If the court rules or decides in favor of Burwell, which is the government's position, there'll be essentially a status quo with states scrambling then to figure out how they're going to respond and what they're going to do. In the event of a King decision, though, the world is upended. And I think what we find often is that in politics and in government service, that people are responsive to the circumstances that they're presented with, and their ability and willingness to invest lots in contingencies is sometimes diminished.
Is there anything at all in all of these studies that you look at? And again, you put it up properly here, because with the litigation that's going on, still waiting on what SCOTUS will do, is there anything that these states can do logically at this point just in order to prepare and maybe lessen a little bit of this sticker shock to the individuals?
Well, what the states are going to be confronted with is this. We believe that in the event of a King decision, that the administration and the executive always had the advantage of a very single voice that they can speak with. And in this case, they are blessed with the ability to say, just insert 3 words, and federal exchange, into the legislation, and it will fix it for everyone. And they will have the advantage of trumpeting that. Congress will then be in full regale trying to figure out a solution to this. And the problem, we think, is that there will be an impasse potentially based on the fact that Congress will divide itself into those who want to replace and repeal, those who want to create a temporary fix, and those who are prepared to more permanently fix this. And our supposition then is that potentially this then devolves to the states to resolve. And we have basically said that the states collectively, those 34 who will be the most impacted, that they have the ability to, in a collective situation, have a much bigger voice and to create much more leverage than they do individually. But that there's going to be lots of pressure that they're going to feel, not just from the consumers, but from others as well.
Rich, we look at some of the other numbers in places like Alaska and places like Wyoming. I mean, Alaska, we're talking about premiums up over 1,000%, almost 1,000% in Wyoming. I got about a minute left here, Rich. Isn't it just naive to think that the administration didn't know this could happen? And the people who go, well, this absolutely is just not what we had planned. You had to have known this. They knew, someone knew this was coming and the possibility existed, because the people are going to be left without insurance.
Yeah, the notion here is that the court is confronted with either strictly interpreting the language of the statute or incorporating legislative intent. And we'll see what they conclude. But But in the event that someone had looked at this statutory language, a fix should have been contemplated much earlier than we're contemplating right now.
And not only that, but at least some preparation taken, yes?
Absolutely. And I think that's what we're trying to do by virtue of presenting this paper. We don't know that we've got all the solutions or resolutions here, but what we wanted to do was to jumpstart a conversation that would begin to have people begin to do some contingency planning that has not heretofore been on people's front burner.
Rich, they should have had you making these decisions a couple of years ago, because it sure would have helped a lot of people right now. But boy, they better pay attention now. Rich McKeown, it's a pleasure to have you on the show. Thanks for joining us and giving us some light on the situation.
My pleasure anytime.
All right. Coming up next, the Obamacare facet that has to go or stop any real innovation in treatment. Next on The Hardline.